So welcome back, everyone, and thank you for joining us again. Our second panel turns from the international level to comparative animal law, and we will hear from four different legal and political contexts: India, indigenous animal law, Peru, and Nigeria, followed by a Q&A. So please feel free to type your questions in the Q&A box anytime. And let's start with our first speaker, Sahana Ramdas. She is an immigration attorney at East Cook Legal Aid Society, and she will present an overview of Indian animal law. Sahana, the floor is yours.
Marine, is it okay?
Yeah, perfect. Thank you.
Okay. Hi, all. Good morning. Um, it's a pleasure to be here. Um, I would like to start off by thanking Professor Schaefer as well as all the animal law advocates who are doing amazing work and are a source of inspiration for me. So, today I'm going to be speaking about the overview of India's animal law framework. India is a common law country with a cooperative. It basically has cooperative federalism. The constitution is the supreme law of the land, and it has codified statutes and delegated regulations. The judicial review power of the Supreme Court is all encompassing and it's quite strong. The directive principles of the state policy do address and direct all the state as well as citizens to have compassion for all living creatures, to protect and safeguard forests and wildlife. That's the Article 48 and 51 AG. The Animal Welfare Board of India is a statutory body which is responsible for enforcing the Prevention of Cruelty to Animals Act. It can also issue directions to concerned authorities to enforce PCA provisions. Many forms of cruelty are categorically mentioned, such as acts as well as omissions, and they are prohibited under Section 11. As we see in other national laws, there's a standard language of unnecessary pain and suffering. So as long as animal use, exploitation, and killing does not cause unnecessary pain and suffering, it is okay under the law. So, as I said, killing of animals for food, use of animals for experimentation. However, increasingly it has been significantly and strongly regulated. In fact, India is taking steps to phase out the use of animals overall. The use of cosmetics, import of cosmetics, detergents, soaps, which have been experimented on animals, is banned. And education institutions have to use alternatives and can no longer conduct experiments on animals. And uniquely, India has the 4R principle. It's not just about refining the practices, reducing the use of animals, replacing them with alternative technologies, but also rehabilitating used animals. Again, India is taking steps to prevent the use of wild animals as well as domestic animals in zoos, as well as other kinds of live animal performances. And religious sacrifices is not considered as an offense under the Act either. The biggest drawback of the Central Act is the abysmally low penal provisions, where a subsequent or repeat animal offender can get away by committing heinous offenses against animals with less than 3 months of imprisonment if the court does want to impose an imprisonment on the offender, and no more than $1 of a fine. In fact, less than $1 of a fine. Henceforth, the Prevention of Cruelty to Animals Act is ineffective in curbing animal offenses, and there's been a surge of crimes against animals in India. However, the Indian Penal Code was replaced in 2023 with the Bharatiya Nyaya Samhita, that's a criminal code. And under that, there's a strong provision called the Section 325, wherein killing, maiming, or rendering an animal useless can get the offender 5 years of imprisonment and or with fine. So prosecutors can use this provision to make up for the toothless provisions under PCA. And the best part about this provision is that does not depend upon the monetary value of the animal. So it can be a wild animal, domestic animal, or a community animal. It is protected under the criminal code. However, unfortunately, the criminal code does not penalize bestiality, whereas the Indian Penal Code had. So a draft 2022 a draft 2022 uh, was proposed, and it's still not been tabled in the parliament, which would significantly increase we should significantly increase fines and fines against animal offenders, and also make bestiality a crime again. So there are several. The central legislation, the Prevention of Cruelty to Animals Act, has several rules underneath it, which govern the use of animals who are considered as livestock. So all of these try to ensure five freedoms of all of these try to ensure that the five freedoms are rendered to these animals during their use or before killing. And the rules have requirements for the humane treatment of animals, with specific rules for handling, care, housing, veterinary support, and even humane euthanasia. It seeks to regulate and supervise the use of animals in these livestock industries. All right. So, an abused animal, when an abused animal comes under the when an abused animal is taken to custody, the accused owner is responsible for bearing the costs of medical care and housing of the animal. The animal shelter acts as the custodian on behalf of the court. So the court sees to it that the victim animal does not go back to the accused owner after conviction. And the pet shop rules, as well as the dog breeding and marketing rules, only permit registered, licensed breeders as well as pet shops to engage in the sale of animals. The animal birth control rules has come under the animal birth control rules has pretty much been persecuted over the last 6 months, but it has a strong set of provisions for the humane picking up of community dogs, sterilizing them, immunizing them, and releasing them back into their street habitats, relocating them or removing them, extirpating them from their communities is prohibited under the animal birth control rules. The Wildlife Protection Act protects wild animals which are listed under its schedules. It defines hunting broadly, and wild animals are considered as state property. So, private possession is extremely limited and stringently regulated. Wild animal definition actually includes fish and invertebrates as per the 2002 amendment. However, the 2023 amendment does not show it in its definition. Even if a wild animal is considered as a problem animal, it has to be properly designated as such, and the chief wildlife warden has to take measures to humanely tranquilize it and relocate it elsewhere. So, killing of Schedule 1 animals is not permitted under the Act until unless it's extremely necessary. And the listing of wild animals under the Act has come under heavy scrutiny because many of the endangered and threatened, less charismatic wild animals are not covered under the Act because of the lack of transparency in which the listing has gone through. So the scientific review process is not rigorous, and so what happens is only like a small portion of wild animals are protected. Majority of them are not protected under the Act, and henceforth wildlife crimes are committed against them. And the good thing about the 2022 amendment was the CITES enforcement provisions, which stringently regulates the import of exotic non-native wild animals. And anybody who wants to anybody who wants to possess wild animals has to comply with strict documentation requirements, and they have to report to the state wildlife warden. And scheduled wild animals under the Wildlife Protection Act cannot be commercially traded. They can only be moved out of the country if it's for scientific purposes or for educational reasons. And private possession, like I said, is heavily regulated. The role of judiciary. So the 2014 Supreme Court judgment in the case of Jallikattu was widely hailed as a landmark judgment because it because it ensured and it guaranteed fundamental, it recognized the rights of animals and empathized with animals and looked at what suffering they go through their perspective. However, recently the constitutional bench has reversed the landmark judgment and permitted the state amendments to prevail, because of which it seems like the Supreme Court is taking back steps and is taking a sharp U-turn from the progressive steps it took initially. Um, so yeah, the state level amendments have been upheld, and once again, bull taming related bull racing sports has been legitimized, and the progression made by the 2014 judgment has been set aside, wherein the constitutional bench has loosely found that the state amendments are constitutional. The court took a sharp turn, and again, um, we saw that in the animal birth control case over the last 6 months, where the court ordered for the removal of community dogs from all public areas and all public institutions. And this not only breaches the supreme constitutional principles like the separation of powers, but this kind of judicial review is also perturbing judicial overreach, as it sidelines the rule of law to make up for systemic failures in implementing the animal birth control rules. And the last part is the Supreme Court again is taking regressive steps, wherein, or it's shying away from taking progressive steps, where it is refused to grant legal personhood rights and shied away from it by saying that it cannot grant constitutional fundamental rights to animals as it clashes with human interests. However, the state high court is taking positive steps and it's being empathetic in its judgments, where it's not just conjoining constitutional principles with fundamental right, but it's also recognizing animal sentience.
Sahana? Oh, yeah.
Yeah,
Please conclude. Thank
yeah. So yeah, there are legal exceptions and tension in the Indian society, because of which the enforcement of animal law provisions is become a challenge. And yeah, there are religious and cultural exceptions which have given way for overuse and exploitation of animals. I will leave it here. Thank you.
Thank you so much for your presentation. Our next speaker is Dr. Kelsey Leonard, Canada researcher in Indigenous waters, climate, and sustainability at the University of Waterloo, presenting a contribution on Indigenous animal law.
Wonderful. Thank you for having me. I think we're just waiting
Yeah,
for
you will need
the
to
screen
stop
share.
sharing your screen, please.
Fantastic. Well, Akwewanikasa, hello. It's wonderful to be with you all today. As was mentioned, I'm Dr. Kelsey Leonard. I'm a citizen of the Shinnecock Nation and also a professor at the University of Waterloo in Ontario, Canada. For those that are familiar with Canada, this is not Ontario. This is the eastern portion of Long Island, New York, which is the traditional territory for my nation, the Shinnecock Nation. We are traditionally known for being Bay people, which we are still today because we're a coastal tribal First Nation on the Atlantic Ocean, and very much also known for our storied history of being whalers and connected to the sea, and also being harvesters and carvers of wampum, which form many of the foundational international treaty agreements for what's currently known as the United States and North America. So I think it's very fitting, as we're talking about animal law and comparative animal law, that much of the first initial treaties, international law that was convened across settler and indigenous nations for North America was constituted with animal species, and so particularly mollusks, as you see here. So I come today to share a bit from my chapter that contextualizes Indigenous animal law in a broader subset or as a broader subset of a body of law called Earth Law, sometimes within a broader realm of ecological jurisprudence, as it is sometimes known. And Earth Law recognizes and honors and protects nature's inherent rights to exist, thrive, and evolve. That includes animal species, kin, and relatives. And ultimately, is a body of law working towards a future in which humans and nature flourish together. And so, in the context of Indigenous animal law, what we are establishing in the chapter provided is that Indigenous animal law, as presented, is the cornerstone of Indigenous legal systems. It's often rooted in our creation stories as nations and peoples. And as articulated in the chapter, it is a definition within the encyclopedia that allows for us to understand Indigenous animal law as a broad body of law that is inclusive of rights, responsibilities, and inherent relationships that Indigenous peoples have with animal kin, that it also is embedded within much of our understandings of our spiritual and legal entitlements as Indigenous peoples. Animals as relatives and kin are also very much interwoven into the politics, polities, and governance structures of many Indigenous nations across North America, which is where this definition is centered. But obviously, there are broader contexts in other parts of the world which have similar understandings. And this understanding of Indigenous animal law is also protected by international law through the UN Declaration on the Rights of Indigenous Peoples. So, what I wanted to also just add as a caveat of Indigenous animal law being a subset of Earth law, we often think of Earth law as a tree. There are many branches on it currently. There are other branches that will fall and others that will grow in future years. But you may know it in the context of rights of nature, ecocide, broader animal rights as are being discussed today, rights of future generations, Indigenous law, human environmental rights, such as the right to a healthy environment. And so within this body of laws where I am situating Indigenous animal law. And I want to acknowledge that this is separate or distinct, as I note in the chapter, from animal control law, animal protection laws that might exist within the civil, procedural, and administrative law of an indigenous nation. So, within the context of North America, indigenous nations are sovereign nations. We have full jurisdictional authority over our citizenry, our territories, and thereby inclusive of the animals and other kin that we interact with and are in relationship with. And a large part of that, as we're seeing in these advancements of Earth law and Indigenous animal law, are even some nations that historically and contemporarily are articulating citizenship to be inclusive of animal kin. And so lots of really interesting advancements happening in that space. But what I want to talk about today is more so Indigenous animal law and this broader conception of rights, responsibilities, and inherent relationships separate from procedural law and more of how we think about legal system processes and governance. So, how do we go about formulating Earth law initiatives that are inclusive of Indigenous animal law? We see them happen in the context of constitutional amendments. Sometimes that may be too much to bite off. So we see folks who start at a local or level, sometimes for within indigenous jurisdictions. This is through a band council resolution, a tribal council resolution. It also could be through the establishment of an ordinance. So there are different types of legal measures and mechanisms that indigenous nations use to assert their sovereignty over different topical areas of the law. We also see, though, that these can show up in amicus briefs. We also see that they can show up in legal initiatives such as declarations. So I'll talk about a few of those. And then ultimately, as well, as I started off our conversation today, is treaty making. And so what is noted in the chapter are some really unique initiatives where Indigenous nations were being excluded were from the protection of sacred species by sort of other settler governing structures. So that might be Canada, it might be the United States, it might be state or provincial entities. And in that exclusion, they were seeing significant harm to species of immense cultural significance. So one example is the buffalo. And so we saw the Buffalo Treaty be signed in 2014 with nations spanning across the imagined border of Canada and the United States to come together to sign a Buffalo Treaty of Cooperation, Renewal, and Restoration for the protection of that species, which has seen immense amount of restoration progress and growth for the species in the past decade. We then also saw subsequently the Grizzly Treaty when there was significant harm being done to grizzly populations through different types of hunting. And largely this was non-Indigenous hunting for sport that was happening for grizzly populations. And so Indigenous nations again came together in 2016 to sign the Grizzly Treaty, articulating the rights, responsibilities, and inherent relationships that these nations have to the grizzly and to its protection and to ensuring its future ability to be able to thrive and be protected. And they had a historic treaty signing and ceremony. So treaty is also not just simply nations coming together to pen the legal instrument, but it's also about that spiritual relationship, the ceremony that is enacted to bring life to that treaty. And so very, very interesting articulations of law. Similarly, the state of Wisconsin and the federal government and others were thinking to delist the gray wolf in a period of 2015 onwards. They were also settler populations found that the wolf populations were encroaching too much to their liking and wanted to do a massive cull. And the nations around this portion of the world, the Great Lakes region, the wolf, Maingan, is a clan totem, a part of their governance structure, very much deep and embedded kin. And they spoke out vehemently against this and were able to stop that cull from happening and also signed the Wolf Treaty of 2019. So the last item that is shared in the chapter is the Rights of River Herring Declaration. So that's also where we see this work going in the future is youth. Indigenous youth are leading some of these initiatives. And in this particular instance, the Mashpee Wampanoag tribe, which is located adjacent to what's currently known as Massachusetts, their youth put forward a declaration that then went through the legislative process of their nation and was signed into law in 2023, protecting the rights of herring, which is a culturally important species and a migratory species. So as I leave you today, I hope that you will remember that there are these amazing initiatives. We've documented them on the earthlawportal.org, which you can go and take a look at. There's also the Eco Jurisprudence Monitor, which is a global data set. That's where the Rights of River Herring image came from as well, that documents all different types of earth law initiatives, inclusive of animal law. So with that, I just want to say thank you to Bhutni and looking forward to the remainder of the panelists.
Thank you so much for such an interesting presentation. Our next speaker is Marcia Condoy Truyenque, doctoral researcher at the Faculty of Law of the University of Helsinki, presenting an overview of Peruvian animal law.
Well, thank you, Marine. I want to first start by being very grateful to Professor John Schaffner for trusting me in the writing of the chapter of overview of Peruvian animal law. And thank you to you, Marine Darcier, and to Professor Katie Hessler for organizing this event. So I was betrusted the writing of the Peruvian animal law chapter. And in today's presentation, what I will do is to refer to the constitutional foundations of the Peruvian animal protection that I consider is the most important part of the animal protection in Peru, even more important than the legislation. And also I will refer to new cases that came after the release of the book. And finally, I will refer to some key important aspects of the new legislation of animal protection in Peru. But well, let's start by highlighting that Peru is a unitarian country, it's not a federal one. So in that case, all the legislation and case law I will refer today will affect to the whole country. Also, it is important to say that Peru has two main legal decision makers. One is the Constitutional Tribunal, whose work is the legal interpretation of the Constitution and is in line with international human rights treaties. So it is very progressive most of the time. And the other main legal decision maker is the Supreme Court, whose role is the control of the correct application of written statutes. So it is very highly formalistic. Nevertheless, both legal decision makers, the Constitutional Tribunal and the Supreme Court, are being very progressive in the interpretation of the legal status of animals in the law. And so also I want to highlight before starting the presentation that Peru follows a civil law tradition according to which the written statutes are the main source of law. But due to the migration of legal ideas, constitutional ideas, our legal system also regards case law as a main source of law. Judicial decisions of lower courts are normally used by other courts as guidance. And also, when the legal decisions come from the Supreme Court or from the Constitutional Court, these legal decisions have a quasi-status decisis nature. They are not explicitly binding, but the courts always follow what the Supreme Court or the Constitutional Court say. But also, these two courts can establish explicit binding decisions, in which case lower courts don't have other option than follow the decisions in those binding judgments. So with that said, let me start pointing out that Peru had its first law in 2000, and this law declared that animal protection against cruelty was a national priority, but sadly, this law was neither promoted, neither known by the people, and neither respected. It was not respected at all. So it didn't mark a real change for animals in reality. But nevertheless, I would like to say that one of the biggest the big progress for animals in the law came in 2004. And in this case, that was issued by the Constitutional Tribunal, the Constitutional Court had to answer to the question, do animals are legally and constitutionally protected in Peru? And if so, which is the foundation of such constitutional and legal protection? In this case, in 2004, the Constitutional Tribunal identified that there are some articles in the Constitution that protect indirectly animals. For instance, the right to a healthy and peaceful environment, according to which humans have to live in a harmonious environment, protect animals because, according to the court, there are many people who feel affected in their feelings when they witness or when they get notice of the existence of cruelty against animals. And also the court established that there are environmental obligations of the state, for instance, those coming from the Convention on Biological Diversity, that indirectly also establish some kind of protection for animals, because sustainable use of resources, a sustainable use of animals as resources necessarily implies a legal protection of animals. But importantly, this anthropocentric protection, this indirect protection of animals using constitutional provisions, the court went further and established that animals are protected in the Constitution by their own sake. So what the Constitutional Tribunal said is the following. As animals are sentient beings, and they are also beneficiaries of legal protection because there are implicit principles and values in the Constitution that reflect a minimum societal consensus. One of such consensus are the essential values for peaceful coexistence. That necessarily includes a peaceful coexistence with other living beings with which humans coexist. And given that animals are sentient beings, the state and any individual has the constitutional duty to ensure that people, and I quote here, people don't act with violence with other people, nor with cruelty against animals, end quote. This is what currently in Peru we call the constitutional duty of animal protection. And this duty has been recognized via an interpretation in 2005 in the judgment I just mentioned. And because this comes from the interpretation of the same constitution, this state duty of animal protection has a superior character, even superior to the legislation of animal protection. Now, this duty on the constitutional protection of animals has been developed forward in new decisions also from the Constitutional Tribunal, mainly in the judgments 73, 92, and 2013, where the Constitutional Court reasoned as follows. So in this case, the Constitutional Tribunal say this. First, Peruvian Constitution enshrines the duty of the state and individuals to respect the life of other people, their physical and mental integrity, their well-being, and their health. Everyone in Peru has the right to life and the right to mental and physical integrity. This is why all actions against these interests are prohibited. So, for instance, in Peru, it is prohibited physical and psychological violence, the torture, inhumane treatments, humiliation, slavery, servitude, human trafficking, etc. Therefore, it is reasonable to affirm that the Constitution is concerned with the production of pain, suffering, and cruelty towards other humans. And the elimination of all those forms of physical suffering and cruelty against humans has been the justification of the most basic protections of modern legal systems of liberal nature. So the court identified that behind the written constitution, there are implicit principles that enshrine liberal ideas that protect human integrity and human life. And the court said, well, if animals have the same nature than humans, why don't extend this principle of prescription of cruelty towards animals? The court said in 2019 explicitly the following. If the physical suffering that a human being can feel is a compelling reason for the existence of a legal duty not to cause physical suffering, why should this consideration be restricted to beings other than humans with the same capacities to feel? So what the court said is that we have constitutional obligations to protect the life and integrity of humans, and it also applies to animals for their nature of sentient beings. Currently, the constitutional duty to protect animals and the principle of prescription of cruelty that I just referred are, in my view, the most important legal tools for animal protection in Peru. So, and these two principles, the constitutional duty and the prescription of cruelty, have been used in a number of cases. Some of them are cited in the chapter of the Elgar Animal Law book, and some are very new. I will refer to some of them. First, one that is cited in the book is the Curuñao case of 2013. In this case, an ethnic Afro-Peruvian group began to practice a festivity in which they were torturing cats, and after they were eating the cats. So there was a constitutional case for prohibiting this practice. And in this case, the judge said that given that these people were unable to prove that there was like an old historical precedence of this practice, they are not protected with the freedom, with the right to freedom and participation in cultural practices, but also it referred to the sentient nature of animals. And this was in 2013, before the enactment of the new legislation that for first time recognized sentience. Now, in 2024, in a judgment of 2024,
Yes.
in the case, okay, you have 1 minute?
You already had 1 minute, so you will need to
Okay,
conclude.
I'm sorry. So, in general, I just want to say, just to finish, that the constitutional provisions of animal protection in Peru are much more important than, I will say, the legislation. But the legislation helps a lot in the legal interpretation. So just for inviting you to read the chapter, and thank you, Marin.
Thank you so much. It was a very interesting presentation. Our next speaker is Mo Esan, PhD candidate at the University of Birmingham, presenting an overview of Nigerian animal law.
Yeah. Hello, everybody. Thanks for the introduction, Marine. Thank you to Professor Schaffner and everybody who's been on the team to make such a valuable book. I have my copy. I have to tell everybody that I'm so excited about it. I've been reading it and it's been really helpful. And just before I go on, I'd just like to also say a big thank you to four of my friends who are also joining, which is Ada, Bernice, Omoli, and Linda. And I just think it's important because they know nothing about this field. So being able to be a part of this webinar, I think it's really important. So I say thank you for that. So my topic is the overview of the Nigerian animal law. And one of the things that I think this chapter makes it very important is because every single time I get this question, Nigeria doesn't care about animals, Nigeria doesn't have any animal laws and things like that. I think they're different questions. Whether they care about animals is one question, and whether we have like substantive, positive hard laws, another question. And so what my chapter has been doing is kind of looking into the hard law, what we have, which I think is pretty strong. So what I'll be doing in this presentation is looking through some of the strongest, which I've highlighted in my chapter, and looking at the projections for the future of Nigeria and what that could possibly do. So I think the first thing that I think is important to highlight is generally in Nigeria, the concept of the protection of the animal has been very different. It's been laced, especially when thinking about it from the judicial perspective, it's been laced with laughter, humor, sometimes some form of unseriousness, really, because when you engage in conversations about animal laws, one of the first questions I found in my experience is people asking, there's so many more pressing issues. And I think it's also in other countries, so many more pressing issues. Why should Nigeria, focus on the animal? And there was a judgment in 2023 where there was some noise pollution, which is what the court called it, from a person who had a pet. I say pet loosely, but a person who had a pet chicken. And after some complaints, the matter actually went to the magistrate courts and the small claims court. And the owner of the chicken mentioned that, well, he's just saving the chicken until a couple of days where he could have a Christmas dinner. And the court actually ruled that, well, he should be given the chance to have his pet for those few days, but ordered the man to kill the pet, the chicken, as soon as it was over. This is a real judgment. I'm not just making this up. And so that caused a lot of uproar in the media. People were just laughing, thought it was funny. But one of the things that was important is a lot of comments said Nigeria actually has nothing to protect the animal, which this book wasn't published then, I would have referred them to. But now that it's published, now we can answer more questions that yes, they are laws. So for example, the first, which has been the longest since before 1960, which is when Nigeria became a federal republic, is the criminal code. The criminal code applies to all the states in Nigeria. There are 36 states in Nigeria, although they're divided into the northern and the southern states. But generally, the criminal code covers everybody. And one of the things it does in section 495 is it actually criminalizes animal cruelty. This is the strongest body of law that we have as a country related to criminal offenses. And in section 495, the cruelty to the animal was defined very clearly and is a source of it's the cruelty wasn't just something broad. They were specific. The law includes maiming of an animal, includes the use of animals for entertainment, except in specific circumstances. And that was all they said. So any act that falls in the category of specific instances will be excused. The criminal code also prevents people from releasing an animal into the wild if it is injured. It divides animals broadly into two categories, which is the domestic animals and captive animals. And captive animals are animals who have been confined for a specific purpose. Domestic animals are animals that have been tamed for human use. In that context, we could safely say that the Criminal Code doesn't have any regulations for the wild animal, although we do have some laws that protect wild animals. Nigeria is also a party to CITES and a number of other international agreements to that effect. But what this distinction does is it makes certain animals separate from certain animals, which is a good thing, which is also well thought out. So, for example, one of the things that the Criminal Code does, this is in section 450, is it actually splits different kinds of animals. So it says that any animal, any person who is in possession of an animal that is not capable of being stolen, and I will explain what that means, but any person in possession of an animal which is not and then he lists the animals, and the animals are a horse, a mare, a gelding, ass, mule, camel, bull, cow, ox, goat, pig, ram, whether ostrich, or the young of any such animal would be guilty of a misdemeanor. But every other animal would be guilty of a felony. Now, this is important because what this legislation is trying to do is put animals into cadres. And so it's not just a blanket statement about cruelty to animals being not desirable, but also like saying that, well, for these specific animals, oxen, bulls, ostriches, and geldings, which are any castrated animal also falls in that category, including fish. And as long as they're not wild, of course, those animals are kind of specially protected. And also there's an indication that the young of such animals also deserve such protection, separate from that. So we have that. Now, enforcement is another issue because there's really not much. I tried to find something that I could hold on to kind of put forth a good argument for the enforcement of animal protection laws. But the interesting thing is this law is about 76 years old and there's been 0 convictions thus far, which is scary, to be honest, because we have such strong laws on paper, but there's been nothing. There's been no conviction. There's not even been an uproar to incite the judiciary to kind of take these things seriously, because I think the state is so burdened with many other issues that these ones look funny. But a 76-year-old law, approximately, it's probably older, a 76-year-old law without convictions is definitely worrisome. However, after the criminal code is still in force, but there's specific states that also have specific legislation. For example, Oyo State, where I lived for a long time, they have these state dog laws. So Oyo State has dog laws. Enugu State has dog laws. Lagos State has dog laws. That's one type of law that is applicable in most of the states. But interestingly, in 2022, something happened. Now, a woman had a dog whose name was Roxy. It's Googleable. And the dog went out and she's been looking for a dog for a number of days. And the dog kind of strayed into a compound, was found in the compound and was actually shot. No questions wrong. And there are videos, so it wasn't like the dog was trying to harm the person, but they said they had an estate law that actually allowed that to happen, which the estate law said that if there was an animal that fell into a person's compound that was unidentified, it could be killed. And so I did some work into the estate law. The estate law does align with the dog law. The dog law is a terrible piece of legislation, some portions of it. And one of the things that it does is it uses the term destroyed. That dog law says that any animal that is found without an identifiable owner any dog can be destroyed. The word destroyed is interesting. I think it's also cruel, or a country that has a code that prevents even the cruel killing of animals, even for food. But the word cruel, and I think this is common to many countries, the word cruel itself is actually not defined. But Lagos State did something I think is phenomenal. And I've been researching animal law and policy for a number of years now, and I can still say I haven't seen something as strong on paper until this law. Now, this law was in response to a number of rabies issues. So it wasn't technically directly about animal protection or animal care or animal love. It was actually just in response to stray dogs and people who had wild animals as pets in Nigeria. As I said, the criminal code doesn't have any legislation for wild animals. So it was very easy for people to exploit this. And an Indian man was found he was found with a lion. He hadn't harmed anybody, but neighbors got upset, and then the Lagos State government responded to this by actually releasing a law. And in that law, Section 13 is very, very, very robust about the implication of animal cruelty, and actually imposes higher, not high enough in my opinion, but actually imposes high sentences on people to have this. And it has a list of 18, well, not 18, about 40 animals on the list. And it says any person who wants to have these animals, it includes dogs and cats, it includes pythons, includes gorillas, which is interesting. Why would anyone want to have that in their backyard? It also includes a whale, which I think is interesting, seeing that I don't think it's even possible for a person to house a whale in their backyard, even if their backyard were huge. It's just impossible. But it includes those animals and says if any person wanted to have those animals in their compound as a personal possession, they needed to obtain a license. Well, it's been 2 years and there hasn't been any application for a license. I, for one, know that my grandma does have a puppy, which she doesn't have a license for. So these are the challenges. So the law is indeed robust. And I think that's what this chapter tries to present. Well, it's about the hard copy positive law. I think Nigeria is doing good and Lagos State in particular are doing fantastic. But enforcement is a whole nother issue. So maybe in the second edition, in a couple of years' time, there will be more to say about the enforcement of the animal law. But I think what this chapter has done is at least put on paper the laws that we have and how strong in some ways and weak in some other ways that they are. So thank you everybody for listening.
Thank you very much, Mo. That was very informative. And thank you all for providing insights into such diverse legal landscapes. We have now some time for questions, so please feel free to add questions in the Q&A box. And I think we have a first question for you, Mo, actually. Do you project that enforcement of these laws can be a reality in the near future? You were starting to touch a bit on that.
Well, I have no choice but to be hopeful. So I'm kind of tempted to say what the reality is looking like, but also I'm also tempted to exaggerate some of the other things that I think are changing. For example, there's been I think there's been an increased consciousness in people about the welfare of animals. And this is not just because of my work. I also think there are a number of activists, there are a number of wildlife conservationists that are involved in the work. And so this engagement is definitely better than it was 10 years ago, that is for sure. Now, on the government perspective, from that end, it's difficult to say. It's a question I find it very difficult to answer because we do have a new Minister of Environment who has promised 2 years old promise that in the coming years, we'll see an increased attention to the welfare of animals and the environment. I'm just kind of put that in a ball, but it kind of added a clause for increased production in the economy. So nothing has been done, but I still think that even if something has been done, it might be it might be antithetical to what we're trying to achieve. But I know that there have been certain communities that hyena fighting has been banned, not as a result of the law, just general community attitudes. I found that very helpful, very insightful. This happened like last year, so it's not in the book. But I think that enforcement will be slow, but I think it will be possible. And I'm hopeful.
Thank you very much, Mo. I think that I've seen some people raising their hand, so just to remind you to type your questions in the Q&A box if you want to address a question to our panelists. And Marcia, I think we have a question for you also, and since I had to interrupt you, I'm sorry again. I will ask you now. How are the recent recognition of rights of nature in Peru impacting the recognition of animals as legal subjects, in your view?
The recent recognition of rights of nature, for instance, we have the recent recognition of Rio Marañón rights. It was a river, it's a river. And it was very well received by high courts. It was confirmed in the second level court, and it was confirmed in the Supreme Court. But the judgment in Sororunrun, that is the first animal law. There's the first case where animals are explicitly recognized as rights holders, has been recently annulled. So the judges of the Superior Court say that the foundations for rights of our animals are not clear. So they mandate to the lower court to release a new judgment with good foundations. We don't know if they will accept the new foundations because the foundations were good. But yeah, it seems like courts in Peru are very happy to recognize rights to natural entities like rivers and mountains, but they are still reluctant with animal rights. And yeah, that's the case of Run Run, that currently we don't have judgment anymore. So a new judgment has to be released. So in general, yeah, it's a question of more than arguments, it's a question of also how willing are the judges to recognize rights to animals. Yeah.
Thank you, Marcia. And Mo, we have another question for you. You spoke about the destruction of dogs that wander into compounds. Does the law lay out reasonable measures one must take to locate owners before such an act?
Oh, unfortunately, no, which is why they kind of had a defense in that case because the law was simple. It's not even a law, it's just a regulation for the estate. But the estate says that for that particular instance, the estate says that if you find an animal in your compound that is unidentified, feel free to destroy. Now, the law, on the other hand, the Lagos State Dogs Law that was in effect said, well, didn't give any procedure as to how the destruction could be done, but it gave you the option of reporting to the animal shelter instead. But there were no animal shelters until the recent one came after the law was repealed in 2022. So I guess the answer to that question would be that there were no measures into how the destruction. In fact, if you thought about it in a if an animal fell into the compound with a very cruel person, you really can't even begin to think about the way that that animal could have been put down. You know, it's hard to think about.
Thank you. Kelsey, how might indigenous legal orders reshape prevailing assumptions in animal law, particularly regarding relational responsibilities between humans, animals, and place?
Yes, thank you for the question. I think in large part what we're seeing with the reclamation or revitalization of indigenous animal law having greater traction on a global stage is this stark contrast between largely Western common law systems that have delineated animals as property. And that is something that is in very stark contrast to indigenous legal systems and orders where animals are not property and have never really been seen as property, but for the imposition of colonial system and law. So I think that is a big area for the global legal community to be able to learn from one another. What does it look like to have a legal order or a legal system in which animals, many of them are seen inherently as beings with rights, with duties and obligations, with responsibilities that humans have to them as well for care. And I think that sometimes that just kind of gets swept under the rug a bit or isn't really addressed with the dominant system. And in large part, I think that's because the legal system is reactive rather than proactive. I don't know that as animal law scholars, we've had an opportunity to talk about the future that we envision and want for the natural world rather than having to react to harm and to violence towards the natural world. And that's a bit of, why Earth law and, as Marcia and others were mentioning, is taking such a foothold in our global community and legal system right now because it is shifting us from that reactive state of allowing for the legalized destruction of nature up to a certain point to a state where we're being proactive and imagining a planet where we have more balance, we have more respect for the natural world, and perhaps that we are reclaiming ancient legal orders that already existed around our planet, not just within the indigenous context of North America, but elsewhere, and trying to repopulate those ideas into dominant legal orders. So, yeah, that's what I think folks can learn and are learning from Indigenous law and Indigenous animal law right now.
Thank you. And actually, building on that, we have another question. Where indigenous legal systems interface with colonial systems via treaty, what potential, if any, do you see for that to allow framing of animals as someone's to be strengthened?
Um, a lot. I think that there should be, more treaty making, internationally and in this sort of transboundary context. The treaties presented to you earlier are international in the context of working across indigenous nations, but not necessarily working with the settler governments who also are transboundary or part of the transboundary context. But I do see collaborative efforts, and I think as Marcia mentioned earlier, we've seen it in river contexts where you have non-indigenous settler municipality or state or provincial or other polity working in partnership with an indigenous nation to allow for there to be parallel legal initiatives that have similar language so that there's not supplanting of one legal order over the other, but that they're written very much sort of almost mirroring each other to allow for both laws to stand in parity and allow for sort of symbioticness and synergy. So one of the great examples of that is the Magpie River out of Quebec, Canada, recognized by Quebecois regional municipality and the Innu First Nation. We haven't seen that as of yet for an animal species, but I think it could be on track for that. And the other one I think I mentioned in the chapter towards the end, if not, it might have been before it came out, but is the Rights of Whales Treaty that the Pacific Island nations signed last year, and that the Princess of Tonga came out at the UN Ocean Conference in June 2025 to say that she's advocating for Tonga to be the first nation within a Westphalian system to recognize the inherent rights of whales. So that's really good and could lead to more substantive treaties and many, many more examples of nations actually recognizing inherent rights of animals on the Eco Jurisprudence Monitor for you all to check out.
Thank you so much. We will check that out. Now turning to Sahana. Given the significant gaps in Indian law regarding the regulation of exotic animals imported and kept as pets, how can we address both the animal welfare challenges and the ecological risks posed when such animals are released into native ecosystems? And could you share your perspective on the scope for addressing this issue within India as well as in the global context?
Yeah, thank you. So the good thing about the 2022 amendment was bringing in specific set of provisions to keep people in check because illegal wildlife trade was at that point in time not just increasing in farm but also it was just unchecked and unfettered because it was not a criminal offense under the Wildlife Protection Act. So yeah, the CITES amendments were definitely a good addition to the act, and under which, if I think the main issue is the enforcement part of it, because the law is there and the law is really strong. There are strict regulatory provisions which people have to comply with. I think it's extremely important that it's enforced, and of course the forest departments are working with the Wildlife Crime Control Bureau in India to improve the conviction rates of wildlife crimes, but then it's less than 2%. So just compliance with the CITES provisions would kind of nip it in the bud with the illegal trafficking and profiteering of exotic non-native species. And yeah, I do also have the concern that the permissions allowed within these provisions would lead to breeding and commercial sale of exotic species within India as well, because it is people can, as long as they report and as long as they report to the chief wildlife warden and the state department, and they have the requisite set of licenses, they can breed species as per the breeders of species license rules. So that is a loophole, according to me at least. So yeah, enforcement of CITES provisions is super important. Now that we have the law, now that we have the regulations, it's extremely important that it's enforced on the ground, and the conviction rates of wildlife crimes has to significantly go up, because India is a megafauna and it's a biodiversity hotspot. So yeah, even I think globally the same thing applies. The lack of enforcement of wildlife crime provisions is one of the reasons as to why crime syndicates can work underground without being worried about it having a deterrent effect. And I think that's one of the major reasons as to why we see illegal wildlife trade not declining at all. And I think most of the nations have strong wildlife protection laws. The enforcement part of it is where governments have to step it up.
Thank you for your answer, and thank you very much for your presentations, Sahana, Marcia, Mo, and Kelsey. And thank you to everyone who contributed with questions. This brings our panel and my role as your moderator for this first part of the symposium to a close. We'll now take a slightly longer break of about 15 minutes and reconvene for panel 3, which will focus on legal status, standing, and enforcement. Thank you, and we look forward to see you back in 15 minutes. Bye.